Hi again. After freshening our knowledge in the basics of legal design, now we're going to hear more on how might we create systemic impact through legal design projects. I would like to make a warm welcome to Marie Potel and Elizabeth Talbourdet from Amurabi. And I'm also sharing the link of Amurabi here from chat. It won't be wrong if I say Amurabi is a legal innovation lab which aims for a satisfying user experience in law. Please see their impressive projects also in this link. I would like to share their biographies. Mary had 15 years of highly reputed law firm experience and then a general counsel experience at the very well-known companies Estée Lauder and Chanel, along with her master's degree in innovation by design. And afterwards, she founded Amurabi to share the potential of the legal design. She is currently a lecturer at Sciences Po Paris, University of Management of Singapore, and Assas, and she's contributing to initiatives of social service. And for Elizabeth, and she's a graduate of Sorbonne, again, Sciences Po, King's College London, and Columbia Law School, and trained as a lawyer in law firms in London and Paris. She discovered legal design working in-house and pulled into the approach of making the legal information clear and actionable, and to change the way legal recommendations are perceived, understood, and applied. She already worked on over 30 projects and facilitated dozens of workshops. Elizabeth, I must confess that when I'm working with Atelier, I felt the same, that you shared your experience in your biography, and I'm really looking forward to hear your experiences that you're going to share today. In this session, we will listen Marie and Elizabeth's experience, and then afterwards we're going to discuss and share our thoughts with them. Please make sure you're also sharing your questions from the chat part, and if you would raise your hand, I'm going to unmute you and you can ask directly. Yeah, I'm just, sorry for the door. I'm just leaving this stage to Marie and Elizabeth.
Hi, everyone. Hi, my name is Marie. So we're going to introduce ourselves briefly in a second, but I just wanted to tell you how happy we are to be with you today. It's a real joy because we've been missing the legal design community a lot. Last time was the Legal Design Summit in Helsinki. It seems ages and ages ago. So it's fantastic. And thank you so much to the awesome organizing team. Thank you so much for the opportunity, because this is, legal design is a movement, obviously, and it's fantastic to be able to see you even virtually. And so this time is really to share views. So really don't hesitate to jump in, raise your hand, or just open your mic to ask a question, or obviously in the chat. But this is really the idea to share views and have this community feeling again, in spite of the distance. And if I dare say, I would have personally gladly jumped on a plane to be with you. Well, some of you in Istanbul, obviously, it's slightly more tricky than that, but hopefully next time. Elizabeth, you want to say a word?
Yes, same thing as you. Very happy to be here. It was really interesting and always a pleasure to hear Margaret. It's always a bit stressful to go after Margaret, but we'll do our best. So should we get started?
Yeah, absolutely. Today we wanted to share views with you, and really in the spirit of having a discussion as much as possible, as to how to create systemic impact through legal design projects. And this is actually not our idea. So we are a legal innovation by design agency that was made clear before. So I guess I don't really have to explain what that is, and I'll jump directly to what Margaret kindly prompted us to do at the previous Legal Design Summit in 2019. We were lucky enough to be there to see her for real. And she urged the community to try to leverage legal design to reach systemic impact. And so she really encouraged all of us to show the metrics beyond individual projects and to try to build on the various projects to reach something bigger, not just, you know, one project after the other, but really try to change this industry for good, to actually change the practice of law. So we were very much inspired by Margaret, as always. So we thought, okay, she challenges us, so let's give it a try.
So just a bit on who we are, because today it's Marie and I, and we're happy to be here, but we're actually really big, getting a bit bigger and embarking a lot of people on this journey towards systemic impact and legal innovation. So what we want to make super clear is that we always are, in the way we work, our team is composed of lawyers and designers. So the point, and I think the way to reach that impact is really this collaborative aspect of our work, and not just having lawyers that try to, you know, design, or designers that would want to be lawyers. That's not really how we work. We really rely on each other's expertise in our own fields to really try and leverage the best out of those expertise towards something different and another way of practicing law, and collaborating to create a satisfying experience of the law at last, because of course we know today it's far less than perfect. We also created a team of experts and built a team of experts around us, because we really believe that in order to reach that impact and go beyond each project, we really need to have a multidisciplinary conversation. So we heavily rely on neuroscience, and we've been working with Dominique Ashby and Mathilde Daroca, who are neuroscience and cognitive science experts, and their input has been so valuable in all the projects we've run, and we'll definitely share some of them with you. And we're also working with financial experts, because beyond the law, and that's also part of the systemic impact, is that we see a lot and more financial documents needed to be redesigned. And so we really need to rely on a financial experts for some of those really tricky financial documents. So this is our team, and it's super diverse and multidisciplinary, and we really love it.
So as to what we do, we wanted to just give you a glimpse of our clients, because we're blessed, I have to say, with a terrific mix of public institutions. So we've been working with the French National School for Judges, with the French Data Protection Authority. We're going to talk about that later on. We're also working with super innovative firms like Google and Ubisoft, and also we're having very large groups, very large companies trusting us. What makes me smile is that I spent about 10 years in one of my prior lives in magic circle law firms, you know, with those very significant cases and huge clients, and part of our clients are the same today. So and what really strikes me is that they come to us with a problem to be solved, or with the beginning of an idea, and they're really eager to make that change happen. So it's not to say that it's easy, and that's also why we're heavily relying, as Elizabeth mentioned, on neuroscience to help us manage change, especially in those large groups. So, you know, I think part of the message here is also, you know, beyond the glam, in a way, it's hard, difficult work that can feel lonely also at times, which is why, you know, when you're faced with significant constraints internally in those very large groups who think they want to change, but actually don't know how. And even though we're trying to help them, the level of resistance is so high that we can sometimes feel a bit, overwhelmed ourselves. So this is also why it's so important to rely on this community to help each other. And this is already the case. So that's awesome. But this, we just wanted to give you this very, very brief overview. And also the fact that we're working, well, in Europe for sure, but also in Hong Kong, Singapore, London, so it's quite diverse in terms of countries as well. Elizabeth, I think this is
sure. Yes, beyond the class. So we wanted to show you really quickly some of the projects we've run to show you the diversity, and also reaching systemic impact means trying to apply legal innovation all throughout all different range of fields of law. So we've created digital platforms to help lawyers and internal clients collaborate. We've designed guides and apps to help users know their rights and navigates complex, legal notions. We've designed litigation submissions to address judges' needs, because they too are users of the law. So it was very important to try and put ourselves in their shoes when designing submissions. We, touched upon all fields of law, from privacy to contract to compliance, and even art law, which was one of our very exciting projects. And I think it's also something Margaret touched upon before. So we really wanted to show you this diversity, because we think new legal forms of collaboration, for example, between art, law, and tech, are super relevant today and will be even more tomorrow. But through all these projects, and all taken on its own, it's not enough. So what we want to do is reach that systemic impact with the compilation of our diversity of clients and projects. So what do we mean by impact? We mean to ensure that a project doesn't stand on its own, but really has a ripple effect and builds up to the next project to enrich all the experience we have. And we especially want to use that to enrich our public services project and our pro bono project, to actually change the way legal documents and processes are used and perceived at large. And so we want to reach an impact that's powerful enough to bring a new outlook on the way we draft legal documents, and ultimately change the practice of the law. We're not saying we're doing it. What we're saying,
we're trying.
We're trying. We're really trying. And I think the most important point here is really to understand that with this ambition, with this ambition in mind, especially in the projects we're going to show you in public service, it really has helped us to go beyond just that one project impact.
Exactly. So now you might wonder, okay, that's all interesting. Okay, but how do you measure that effect? You need metrics, as Margaret Hagan said. So we've been thinking a lot about this idea, and to be honest, from day one, when we started the agency nearly 3 years ago, we were aware of the importance of measuring the value. So we tried to identify KPIs from the start. So we had been doing that for nearly 2 years, when we realized that this was a limited approach in a way. So, we would start a project, and during the launch meeting, basically the launch session, we would ask the client or suggest to the client a number of like 2-3 KPIs, and we would jointly agree on exactly what to measure. So, it seemed okay as a start, but then we quickly realized that even though the clients got super enthusiastic about the project, and we always got very positive feedback, we realized that this was an additional burden on them to keep measuring the KPIs after the project, because obviously, it's you need to measure that over time. You need a reference point, obviously, and then you need to see what has changed, maybe 6 months after the completion of the project, even 12 months afterwards, so that you don't lose the benefit and you ensure that there's also continuous improvement. So we realized that over time, that energy on our client side tended to decline. Of course, they're snowed under, they have to do always more with ever less. So we thought, okay, we need to do better than that. And also the KPIs, the nature of the KPIs that we identified was like sort of top of mind,
Bit untangible.
So, it was a start, it was good intentions, but we really wanted to enshrine this approach in scientific methodology, to have very reliable, very, even scientifically grounded principles behind that. So it was during confinement, the first confinement last year, I think, in France. So like February, March probably, we took the opportunity actually to work with a fantastic expert, Mathilde Darochat. She's a PhD in cognitive neuroscience and an absolutely amazing person. I have to say, we're lucky that she agreed to work with us. So she collaborated with us to create a methodology, to create a test, a user testing lab rather. So our lab is actually a methodology. So in our lab, the objective is to measure the value of our deliverables according to international standards. So, given that she's a specialist in user-centric design and conception, she took as a basis all the best practices and even the international standards, the norms that are applied to very different areas, absolutely not legal documents to start with. And then she adapted those standards to basically our deliverables. So it could be, contract redesign or compliance programs or even processes, or obviously digital documents and platforms. So how do we do that? So in order to evaluate the most objectively as possible the quality of a document, the starting point is that documents are actually artifacts, just like any object, really, with which users interact. So the quality of the document, just like an object, affects the quality of the interaction. It's like when Don Norman explains that some objects have the power to very intuitively suggest the way they are used. It's about the same idea. So the quality of the interaction with the document may affect whether the user gets into action based on that document or does absolutely nothing, which in our area can be a problem if you think about even contracts or compliance programs. So obviously the quality assessment is based on a variety of factors, and all these factors are assessed in detail in our methodology. So what we assess, it's quite detailed, and I don't want to bore you in any way, but basically there are three main questions that we try to answer. We are assessing the readability of everything that we do. That's obvious. That's kind of level one. So in order to do that, obviously we rely on all these international standards that you probably know. There are formulas to define whether a text is easy to understand upon first reading. And all those tests, they vary. We've named a few here, but they're all based on the same principle, which is measuring the density of the words, which is the number of syllables, and then the density of the sentences, so the number of words in a sentence, and obviously the length of paragraphs as well. And based on that, you've got algorithm telling you that the reading age of a document is either 13 years old, maybe that's Harry Potter level. And some clients come to us saying, look, I've got this life insurance contract, let's say, and I want a Harry Potter reading age. This is not to say, obviously, that 13 years old are going to use these agreements, but they want the language to be that easy to understand. And then, of course, that's not enough, because you've got a reading age, and most most reading ages when legal documents come to us is usually 3 to 5 years after A level.
Yeah.
Top
So
of mind, yeah. So it means that it takes between three to 5 years of postgrad university studies to understand. And that's there's also a classification of language. I don't know if you're familiar with it. Within Europe, language has been classified in, from A1 to B2, I think. And B1, the level B1 is what's usually understood by most of the population, but most lawyers usually speak in A1 or A2, which is the, or even, no, I'm getting this wrong. This is the other way around. Sorry, they speak in C2. Or C1, yeah, my apologies. So anyway, the readability is very important. Obviously, it's the starting point. If you don't get your language right, then you're killing the experience, that's for sure. But that's not enough. So we also have to measure acceptability and acceptance. And so this is slightly more complex to the extent that it's the question whether the user is going whether the user is going to feel like using the document. Is it something that he's prompted to do thanks to the form, thanks to the ergonomy of the document? So it's quite complex. I don't want to go into too many details, but for those of you who are interested, we're more than happy to share all the references that we are relying on if you want to do your own testing. And then, of course, there's usability. This is absolutely key. As you know, design is obsessed with usage. That's why it's so valuable to combine design and the law, because the law lacks usability terribly. So usability is measured in absolutely all of our projects. And I think it translates quite well in our KPIs. If we turn to the next slide, because, for example, we're able to save 2.5 hours per week per person through the redesign of a contractual process. So, of course, we shouldn't stop there. It's not an end in itself, and there's still a lot to be done. But still, we've noticed that that kind of KPI also triggers a sense of pride within the legal division at stake, and it creates an overall dynamic through change, so that they're prompted to do one more project and go on with this dynamic of change. So it's not just about the metrics; it's also about a value that's slightly more intangible, which is the dynamics and willingness, and also the satisfaction. Happier lawyers, I guess. So to continue with the metrics, however, because that's also how clients internally get their budgets, to facilitate all these projects. So we managed to divide the lead time by 2 in an NDA project, and I think we can do even better, to be honest. But we're working on that. And in a compliance project with ICC Belgium, we managed to increase understanding by 60%. And again, we're not saying, hooray, we've done that, that's it. Especially in terms of compliance, I think it's absolutely key to go way beyond this 60% of understanding. That's not enough. We want to increase it by 200%, of course.
And I think, it's really important to understand that KPIs are very reassuring in their metrics and their data. And so it's very important for us to measure them. And that's what we can bring beyond the next project. But all the experience and all, each difficulty in each project is also something we can't, show and measure so much. But it's been a learning curve over the past 3 years, and especially with the lab. And so what we want to do with this lab is, of course, go beyond and develop further the lab and test our methodology towards continual improvements of all the deliverable, as Marie said, not just be satisfied with 60%, but go at 200, 300%. And also we want to leverage these learnings and build them towards a new normal, a new standard, and especially with projects that can touch a very large audience. So this is really bringing us to our public service projects. To reach systemic impact, we believe it's also about who we're talking to and who needs to be touched with more accessible law. So Marie, I don't know if you want to talk about this project a little bit more.
Sure, gladly. We spent last summer preparing our case to submit our offer to a public bid for the French Data Protection Authority. We're lucky enough that our work was rewarded. So we got the bid, and this project has been really lifting us, I think, since September. The CNIL, so the French Data Protection Authority, wants to protect underage users, and in particular, it wants to help them, to prompt them how to much better understand and obviously exercise their digital rights. So unfortunately, we cannot show everything because it's not finished yet, but everything in the end will be published. We're going to talk about that. But their goal is really to have this fine balance between protection and empowerment. It's very, very important to understand that it even goes beyond offering practical advice. It's about empowering underage users so that they can be better protected. It's very important to acknowledge the fact that childhood is this very strange state where, of course, you're more vulnerable, so you need more protection. To share also their learnings, beyond all the articles that were published. So, a lot of preparation, and that's really in line with the systemic impact. I think one of the problems, one of the weaknesses of lawyers when they're trying to tackle change is probably to have the tendency to reinvent the wheel by themselves. They want to do it all, but then they tend to forget the benchmark, which is odd because, researching your
about asking them very specific questions, and we compiled the data with Mathilde as well, using a very strict methodology to really create profiles of different kinds of profiles that would fit the reality the more we could. And we also wanted to rely on their insights, because a lot of the research showed that adults think instead of children, and they think they know what children think and want, which is not true, because it's very different to be a child before, in the 1990s than to be a child today. And I'm not even talking, way before that. So of course, it was very important to include them also in the co-creation of prototypes. So this is the very, very limited prototype stage that we were, we can show you. Of course, the final deliverables will be published under Creative Commons license, and that's not for us to share right now. But we really wanted to insist on the fact that having your users co-create with you is, enables us to help them understand and explain in their own words such complicated issues. And that goes for children, but it also goes for marketing. If your users are going to be in marketing and you're serving internal clients, understanding their language and putting
all designers, well, obviously the French Data Protection Authority is targeting French designers, but given that this is GDPR, this is based on GDPR, it could very easily be applied by anyone in the EU. And the whole idea is to create methodology kits. You can see just the covers of some of them here, but also use cases so that they can easily translate and see the implementation of the methodology, which is very detailed, into actual use cases, so they can get inspired. And we were very careful, we obviously worked with a lot of our designers, but also the design community around us, and we were very careful to not impose a sort of bulky recipe that they would necessarily have to apply. That's absolutely not a designer's mindset, obviously. So we were careful to create bits and pieces that they could grasp depending on their own needs, on their own thinking about the matter, on whether they would have, just 5 minutes to maybe improve the language, or maybe more time, so that, they could have a variety of tools, really like a toolbox, that they could resort to depending on their needs and their willingness to empower underage users to better understand and apply their rights. And we're currently even creating tutorials, so small video, 2-minute videos that will be on this website that you see here. So this site already exists. It's the Innovation Lab of the French Data Protection Authority, and all the content you can see there is actually directed at adults. So basically, in a couple of months, hopefully, you will be seeing all this toolbox and all the various methodology kits, case studies, resources, tutorials under a Creative Commons license, and in an English version. So pretty much for everyone. Now, we didn't want to stop there. We're getting, I suppose that you're getting to know us now. We kind of never stop. That's why sometimes we're a bit tired. But we thought, after having created all the material for the co-creation workshops with the children and teenagers, we thought that we had actually so much raw material at hand that it was, in a way, was silly not to try to do more with it. So we are currently working with the team at the CNIL, because they've got a special team working with national education and associations. So we're thinking that we could relatively easily transform, if we go back to the previous slide, sorry, Elizabeth, transform, for example, the storytelling that we used to explain to teenagers the concept of cookies. We leveraged the image, the symbol of the amusement park, and it worked quite well. So we thought, based on that result, maybe we could transform that into a toolkit that could be very easily used by teachers, parents, pupils, that could create, like a network of volunteers, and we would, and the CNIL would maybe train a first team, and then information would cascade thanks to the toolkit, and maybe, in a couple of years, probably we would have much more awareness among underage users as to their data protection rights. And this is, this is not just because the CNIL asked us to do so. If you take a step back and just think about the type of citizens that we're creating currently, if we tell them that it's okay to blind sign data privacy consent, as we do, as most of us do, then what does it mean in terms of strength of our democracies? That we give up all our data privacy rights, which is a daily thing that we currently do, when we tick the box without reading. So I think it's, it's ambitious, but it's also up to the level of the threat to the democracy if we get the habit of giving up our rights so easily when we navigate online.
Exactly. And just to answer one question from Essen in the chat before we move on from this project, how much time did you spare for the research for the project with children? I think it was several weeks. So it was, at least.
I think, well, part of the research started even when we were answering to the public bid. So that was at least 3 weeks in August. I remember that clearly. And then let's say at least 3 more weeks when we got the project.
It's also because there was a lot of preliminary research, and we also extended research, beyond just the data protection or, even just usage online of children. We also went, we read much broader research about children in general, and just the way, they act, and a lot of neuroscience research on how adolescents are more risk-taking, which was, something
interesting.
So yeah, I'm just conscious of the time, so maybe
we should move on.
So we also wanted to tell you about how we can create systemic impact with a tool. So not just a project, but really a tool that could be used at large by a lot of people, and that's our NDA. So what we read a lot of NDAs because we've redesigned a lot of them, first of all, but also because every time we have a project with a new client, of course, we sign an NDA. So we've pretty much had a benchmark all throughout the past 3 years of how bad NDAs are. So we really wanted to leverage. We thought, okay, what could we do instead of redesigning one NDA for this person and one NDA for that company? How could we leverage all that insights? And so we really went through all the pain points in the projects that we could see. So NDAs all throughout are time consuming, they're full of jargon, they're not read, they're blindly signed. And because they just are at the very beginning of the process and everyone wants to move on really fast, they just sign it. And when they do read it and it goes back and forth in negotiation, it just feels like it's slowing down the business. So it was very much something that sometimes people even didn't go through. It was a step that they just skipped because it was so painful. So we also did a lot of research on other beyond our own projects, what were the best practice, what were the worst practice, and really tried to see how we could leverage all this into one tool that actually solve these pain points. And is it possible to really remain user-centric when you work on a tool that is destined for users at large? Because of course, user centricity also means that what we do is a bit, tailored. And I like to say that we're the high-end couture of the law, kind of. So it's true that it was a real question on how do we remain user-centric with something that's supposed to touch such a broad range of people. And so we gave it a try. Maureen, do you want to talk about it?
Yeah, we gave it a try, and the point here is again to have a discussion and to have feedback, because we this question remains open. So the way we tried, let us explain. We tried to solve the pain point, the main pain point, the first one at least, which is too many pages for something that's relatively simple. So we solved that with easy navigation. So this is a completely digital NDA. Of course, most versions are full of jargon, and we leverage plain language throughout the document, but in particular, we added a welcome message. Of course, most NDAs are way too long to complete, and also there's a complete lack of engagement. Most people absolutely do not read them, let alone implement them. So we inserted the read time, which has been proven to double engagement. So of course, a classic pain point that we've seen in many different projects is, wait a second, I don't even have the info to fill in this contract, and it takes time to chase the info. So why don't you legal people deal with it? So we solve that with help bubbles, guiding the user to fill in the information much more easily. That's not specific to NDAs, of course, but it's a classic that you have to read at least 3 different clauses to know when the contract starts and when it ends. And it shouldn't have to be like that. So especially for an NDA that has the specificity, there's a validity duration, and then afterwards some obligations might survive. So there's a start date. And then you can click on the duration, and there's an automatic end date completion. Then, of course, we've seen very, very clearly in our projects that most of the parties fail to define what it is that they're going to work on sufficiently well, and that's really a legal risk. And this is where the legal team can add value, but it's so difficult to get hold of them. It's so time consuming that eventually they usually don't do that job. So again, we leveraged help bubbles to really define what they want to protect. Then obviously, the main problem is, okay, what do I do with the information? What is confidential information, and what do I do with it? So here we use do's and don'ts. It's very classic, but maybe slightly less in a contract. So it gives a lot of clarity as to what to do and what not to do. And then, of course, we're amazed by how archaic the signature process was, even with listed groups, Fortune 500. That was kind of weird. So we solved that through electronic signature, of course. I realized that there might be an issue with the slides, but never mind.
Yeah, oops, sorry, I had just a tiny thing.
No worries.
There we go.
So, as we fix the slides, our question now is really, is it enough? Is it sufficiently true to user centricity? And can user-centric tools become the new standard? And we don't have the answer to that. So we're more than happy to hear your views and have a discussion on that. And Elizabeth, maybe you want to talk about the last point, how we also changed the lawyers' state.
Sure. I see that there's one comment. I'm sorry.
Great.
Projecting and using Zoom is really complicated.
It's not easy.
Yeah. Marie, can you see the comments? Or?
Yes, sure. So SN is telling us, yeah, definitely, especially with the rising of legal tech products. Yes, what I'm a bit surprised to see is that even though there's obviously a lot of legal tech products and a lot of contract automation, the automation process is awesome. However, the text is still that horrid wall of text that we used to see in the 80s.
Yeah, there's no design. There's been a huge improvements in the digital signature.
Oh, and Astrid is sharing her experience. Hi, Astrid, good to see you, and even virtually. So we tried to install an NDA app as well, and users were skeptic using it because it did not feel legal. That's so interesting. It has to be impossible to understand to be legal.
Yeah, exactly. So just jumping on here, but it was so interesting in the test. Oh, I'm so sorry with the background. It was really interesting that people wanted to have it more legal, and having an app installed was just too visionary maybe in the moment. I would not say that it could be a new standard. And I think your question is super important, but we have to maybe raise awareness more that a tool could be also an answer. So just a little comment from my side.
Thanks a lot, Astrid. And this is very valuable experience. It always makes me laugh, you know, the level of resistance. And also, I have another question. Are these legally accepted dematerialized contract, are they usable in court? Well, as far as digital signature goes, there's a European regulation that dates back to 2014, saying that, yeah, well, if your electronic signature provider fits, you know, the standard in this regulation, so we're talking about DocuSign, USign, and the like, then yes, of course. And we're having many discussions with judges. We're working with the school for the National School for Judges, but also with other magistrates. And, you know, they have this very, very candid answer, which is, you know, there's freedom of the parties in contract law. What matters is the good old intent of the parties. As long as this is clear, why shouldn't it be valid? So of course, you know, maybe what's behind your question is, you know, can you have like a PDF, a signed PDF of the entirety of the contract beyond each of the screen? And the answer is obviously yes.
I think one thing I wanted to say in reaction to Astrid's comment, we had fascinating workshops where non-lawyers, when we do plain language, try to write in a lawyery way there. So, you know, so we say, okay, this is a plain language exercise, and the people who are, you know, non-lawyers and should be, you know, the ones who don't feel like they have to make something legalese are the one who immediately think, okay, if this is legal, then I need to make it sound legal. And I think it's the same sort of, you know, mindset of having something that feels legal, that sounds legal. And of course, that's why, you know, change management is so important. It's actually a really great transition to
the next question. Yeah, we have a question about e-signature being handled by government-approved platform. It's not government-approved, you know, it's all derived from this 2014 EU regulation that sets a number of conditions for the electronic signature to be valid. So as long as your provider meets those conditions, then he's certified. And if he's certified, then the electronic signature is valid. Yeah. So yeah, state of mind.
Go ahead, Marie.
Yeah, I've completely lost track of who says what, but that's okay. So as you've probably seen, the legal design community was completely over the moon 2 days ago when the Financial Times published this article mentioning the Legal Design Summit. And really, you know, kudos to Pilvi and her amazing team, and obviously to Margaret, who was so inspirational on that day, and all the speakers. So the Financial Times you know, got interested in the question as to how design thinking can help lawyers to do a better job. And the article puts the emphasis on the data-driven approach, for example, the very rigorous testing, which, you know, we all love, obviously, and we've been talking about our own metrics and data-driven approach. Now, it shouldn't make us forget that the most powerful and important tool in legal design is empathy. And this is where it gets really problematic, because how do you change the lawyer's state of mind, and how do you make them embrace empathy, Elizabeth?
So we try to do that with a user's profile to, you know, really build empathy among lawyers and all the, you know, users we work with on different projects. And we have to say that has been the most challenging part, is really to change the state of mind, because it's so enshrined in everyone's, you know, way of practicing law, to go start with the law and then apply it to a situation, rather than, you know, wondering what the situation is and then applying the law to it. So really that switch has been quite a challenge, and still is, but we're really trying to get there with the user profile, really explaining that, you know, giving a profile of personal information, so giving them an age, knowing what their hobbies are, all that really enables you to empathize with the users and really think about one given person. Although even though it's not a real person, of course, it's an archetype. So it's a combination of what, you know, who the users are, and with, you know, their criterias and all that. It's really important to sort of identify someone in your head, because otherwise you eventually go back to your own pain points and your own issues and your own usage. So we really try to highlight this point. We also really, of course, that's necessary in the way we redesign document, to really understand the, you know, habits and goals, the office routine, the way these people work, because if you fit into their work, they will use your document, rather than if it's another hurdle they have to go through. So it can give indication. It's given us crucial indication on the redesigns of certain documents to know, you know, whether they're digital friendly or not at all. There's no point in pushing a digital, you know, tool or document just for the sake of it being digital in 2021. The point is whether they're going to use it, and if your users are, you know,
Ready.
Yeah, ready. So it's very important. We also, of course, understand the understanding of the law. That's something everyone gets. Everyone understands that point, that, you know, you need to start at someone's level. So that's actually where I would start if you're feeling like there's resistance to, you know, empathy, is really that point, understanding of the law of the user, and then also their frustration, to anticipate them and solve them in the new document. So what is their challenge with that document, and how can we solve it? And sometimes it says, you know, what we put in the NDA is finding one pain point, trying to find a solution, testing it, seeing how it works. But having those in mind ahead is essential, because that's the only way to create a document that's going to be meaningful.
And of course, part of changing lawyers' state of mind also lies in, you know, encouraging their creativity. So there's an very old misconception that lawyers wouldn't be creative. It's quite the opposite. Otherwise, how would we overturn ruling and find solutions to our clients' problems? And also, creativity is really like a muscle. Everybody has one creativity muscle. It's really a matter of how often you train it. And there's never too much training. training of your creativity. What's really interesting is that the Oxford Nesta study on the future of skills identified creativity among the 5 key skills to still have a job in 2030. So, you know, beyond the slightly provocative title of the study, I think, yeah, it's absolutely key to also go beyond this, you know, soft skill saying. I hate this expression. It's everything but soft. You know, if it's what's going to help you still have a job 8 years from now, it's not soft. So maybe, let's have a challenge. Maybe we can all find a much better term for soft skills. We've said here behavioral skills, but I'm sure you creative people in the chat can get into action and find a much better word for that. What's for sure is that those skills, this ability to reach out to your users' needs and frustrations, do play a key role in transforming the industry. And that's this is basically that's it for us, and we're happy to have any questions.
Yeah, there's a question. Are you making tailor-made projects specific to companies, or are you licensing your product, or how does it work if an in-house counsel wants your product to be used in her company? That's a great question.
Okay, so until very recently, we only did projects, so that's obviously tailored to companies' needs. But you know, as we explained, we thought that maybe we could create a product, which is this beginning of an NDA, and yes, the idea is that it could be licensed either on shelf or slightly tailored to a client, but like, you know, adapting the graphic charter, putting the client's logo and maybe changing 1 or 2 clauses, but not more than that. So that's the idea. And a big hug to Marisa as well. Thanks, Marisa.
Are you going to share the presentation? Sure, we can.
Yeah, sure.
Yeah, happy to.
So I'm still waiting for this fantastic killer new word for soft skills. Come on.
We brainstorm this one: interpersonal, behavioral.
Yeah.
What is it?
We could do a round robin.
Community skills, yes, why not?
Community, yeah.
Humane,
yes, humane skills. Yeah.
What do you recommend for a lawyer to get started with legal design? What is the starting point? I think the user profile and empathy is really the starting point.
Yeah, and I would state the obvious, but Margaret's website and book is the absolute indispensable thing you need to read. And I have to say, you know, this is also really how I started. I spent my summer in 2017 browsing Margaret's website, and I couldn't have enough of it. I just couldn't. And I thought, you know, after having read everything, I thought, okay, I have to give it a try for myself. And so I flew to Helsinki for the Brain Factory, and that's how it started, really. So we're having human skills, yeah, collaborative skills. Yeah, I like this one. Ooh, love it. Great, thank you.
I don't know if we're out of time.
Yeah, do let us know if we're late or if we still have a couple of minutes.
We have 2 minutes.
Okay.
Okay, great.
What is a good way to measure understandability of the documents?
There's a quick test to do that, which is called the clause test. Let me type this. Clause test. No, with a Z. That's it. And it's like a game where, you know, you take a paragraph and you remove 1 out of 3 or 1 out of 4 words random, in a random way, and you give the user maybe a limited time. I think in our workshops it's usually 1 minute, well, depending on the length of the paragraph, and you see whether they get it right, and you measure the number of right answers. So you can get very easily very precise stats on the understandability of the document. Another way, which is slightly more sophisticated if you have more time, is to give them a usage scenario Like, you know, in data privacy, for example, you say, you divide the users in two groups. One has the old version, the other has the new version. They have the same scenario, like what would you do to exercise your access rights, for example, without further explanation. And then you see who gets it right among the two groups, and how, you know, you attribute a number of points. First, you know, do they understand the question? Do they get the steps right, etc. You have a grid, and then you just count the points. Okay.
Out of time, but thank you so much, everyone. And yes, Marissa, Legal Hackers The Hague would love to invite you to continue this conversation.
Yeah, well, of course, our pleasure. Hopefully in person. We're so eager to travel. And yes, of course, plain English. Yeah, we can share tons of references for plain language as well. Yeah,
sure.
Happy to.
Don't
Have
hesitate
you decide
to
the subject to focus on? What are the measures? Is it complexity or applicability? You mean the subjects in the project, or how do we choose our projects?
You can send us an email with
yeah, maybe we can, your projects. Well, you know, clients come to us with projects, and sometimes we say no, very, very seldom. We say no when, for example, they don't want us to touch the text, and they just want a pretty layout or cover. So in that case, obviously there won't be an impact, even we believe that it's counterproductive, so we refuse those projects. And otherwise, well, we always choose our projects so that we can get maximum impact, of course. Thanks a lot. We don't want to
burn your time.
Yeah. Thanks to everyone.
Marie and Elizabeth, thank you very much for this uplifting, energetic, and informative session. Indeed, it was just amazing.